stand by while NCLA cuts through the noise to signal abuse of administrative power. This is Administrative Static with Mark Chenoweth and John Vecchione.
Welcome to Administrative Static. This is John Vecchione, and our announcer for once was wrong because Mark Chenoweth is not with me. He's out, but I am very happy to have Jenin Younes here with me, our colleague at New Civil Liberties Alliance, to discuss the case of Missouri v. Biden, where we represent individual clients who were thrown off of various social media at the behest of the government, and are certainly through the behest of the government's policies inflicted upon these social media sites. And you've probably seen it in the news besides just this podcast, but we are in discovery for preliminary injunction, and things are moving fast and furious, not only there, but also on the fact that Elon Musk has taken over Twitter. And, the telephone calls coming from inside the building now, as far as Twitter is concerned, and the people in the government and what they were doing. So, Jenin, welcome to the program.
Oh, thank you for having me back.
So, lots going on in this case. Maybe we discuss first, the government wants to get out of it.
Yeah. Yeah. So the government filed a motion to dismiss. They're arguing, one of their primary arguments is lack of standing, that the plaintiffs haven't shown that they've been injured by the government's action, and that any sensible injury could be redressed by government stopping what they've been doing.
But of course, that would not mean that they couldn't restart at any time.
Yeah.
And I do have, they've moved. They want to get out of this case.
Yes.
And one of the things that happened here was that the Fifth Circuit asked the district court to say why he had allowed preliminary discovery in the preliminary injunction rather than have the motion dismiss filed first. And what the judge said was, well, where is this motion to dismiss, right? This thing was filed in July or something like this. What's happened? So they finally came, and it's a big motion to dismiss.
Yeah.
But the arguments there seem to be things we've seen before. It didn't look to me that there's anything greatly new.
No, and that's in part because we had a very similar case that was dismissed in May in the Southern District of Ohio, and the government made very similar arguments in that case and was successful, although we think they shouldn't be.
That's Changizi, right?
Yes, that's Changizi.
That's our case, just to be clear.
And I think actually another really important thing to note is that the government is arguing in the motion to dismiss that there's no proof of coercion. So I don't think at this point they can argue that there's no proof the companies and the government were working together to censor people, because there's so much evidence of that. Just massive amounts of evidence where the government is telling the tech companies you should be censoring this type of post, or even this specific post or this specific person. So now what they're trying to say is that absent evidence that the government was coercing them, basically forcing them to do this, that's not state action, and that means there's no First Amendment claim. We think that's the wrong way of looking at the law, because the government shouldn't be able to work with private actors to violate your constitutional rights. The government can't hire a private company to go search your home when they don't have enough evidence to get a warrant. So they shouldn't be able to hire a private company or work with a private company to suppress people for expressing viewpoints they don't like.
Yes, and I agree with that, but I think it's a more nuanced discussion. I think that Judge Posner has said this in the Seventh Circuit, that they can't do this, almost in the same fact pattern. But there are this other host. I was reading David French, who's now going to the New York Times from the Dispatch, but he said that, look, the government does have First Amendment rights. It is allowed to speak. That's why it has Smokey the Bear and things like that. They're allowed to say, don't create forest fires and stuff like that. So they have a First Amendment right. But I think that one of the reasons the motion to dismiss is really bad here is that the issue of whether coercion what happened here amounted to coercion strikes to me as a fact question.
That's true. That's true. It is a fact, and that's another reason that it's not, appropriate for a motion to dismiss stage. But back to your other point, I mean, the government has First Amendment rights, but the government doesn't have a First Amendment right to try to get private companies to do something that's unlawful. So, I mean, that's different. And what we're arguing is they're essentially encouraging, at least. I mean, I would say they're coercing. I think, again, there's enough evidence. But
well, let's say it's not unlawful for well, the one thing that really I'm like the last Cold Warrior, so I'm always surprised at certain things, and one of them is we have a radio station here in Washington D.C. that it's Sputnik Radio, I'm trying to think of it right now, but it's Russian backed, and it does things that are that the Russian government would like to have on. Well, so if Vladimir Putin wants to give a big speech to the American people on that, and government calls up and says, we don't think any broadcaster should be doing this. If they just say that, is that coercion?
I don't think so. And I think it's a little different because, first of all, it's not about viewpoint-based censorship. It's about a foreign actor trying to sort of interfere with our
but I was going into another point. There is the foreign actor, but they're not saying we're going to pull your license.
Well, that's yes,
right. But here we do have the implication that there are. What are they going to do? They're going to do, first of all, they're going to say people are dying, right?
Yes.
And the COVID thing, the government's going to come and say people are dying because of what you did.
Yeah.
And what does that provide? That creates liability.
Right.
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 If you are creating people to die, I was a plaintiff's attorney. I know there are plenty of guys out there who would sue saying, look, you caused people to die.
Yeah. Well, and the government has also not only said that, but said, and they will be held accountable.
Right.
So they've been pretty, one would call that almost an explicit threat, not an implicit threat.
Exactly. It's not like, here's my advice.
Yeah.
And if you don't take it, well, let the chips fall where they may. You will be held accountable. Well, that's consequences, right?
Exactly.
And there's also all the stuff in there about how the social media people dealing with the government sure seem to feel put upon, at least.
Yes. And that's some of the latest stuff that actually came out in, I think, the 9th or 10th edition of the Twitter files.
And tell them if somebody's not as online as perhaps, well, I'll just say you. It is, what are the Twitter files?
So the Twitter files are Elon Musk, once he bought the company, had promised to let the American public know about the inner workings of Twitter and what he considered to be the censorship activities, why that was happening and what was going on behind the scenes. So he's been releasing it in stages through a few journalists, sort of First Amendment oriented journalists like Matt Taibbi.
As long as they first publish it on their Twitter feed, yes. Right?
Yeah,
exactly.
So they're all written in Twitter threads, which can honestly make it a little difficult to read.
It's true. And then afterwards they publish it regularly. That their deal is that first they got to do it on Twitter. And so you see these like long things of, and so it's Matt Taibbi, and there's another fella,
Barry Weiss, David Zweig, and Michael Schellenberger have been the first so far.
I don't know Schellenberger. Who's that?
I hope I'm not misspeaking. Okay. I think he's a politician in California. I think he ran for office in California, but I'm not 100%.
Okay, and what's his issue?
Like anti-COVID restrictions, libertarian platform.
I got it.
So I think he ran against Newsom.
I got it. Yeah, I got it. So there we so we have this the Twitter files coming out, which I think also there's some resonance in our case, because if material that came out there wasn't produced in discovery, that could be a problem.
Exactly.
Right?
Well, and two of our clients, Jay Bhattacharya and Martin Kulldorff, were specifically mentioned in the Twitter files. So they were, Bhattacharya especially was placed on a Twitter blacklist, which meant that his tweets were not seen, they were de-amplified. And it said the command, the internal Twitter command to put him on a blacklist said, do not amplify these tweets. And then Kulldorff too had there's internal communications about censoring him. Now, I mean, incidentally, Kulldorff is considered he's among the most cited vaccines specialists and infectious disease experts in the world. And you have some guy at Twitter saying we're going to have to take action against Kulldorff because what he says about the vaccines doesn't line up with what the CDC says. I mean, that sort of shows the shocking.
Exactly. I got my Bachelor of Arts at Bryn Mawr, and I'm now going to get Kulldorff off for not saying the right things about.
And it shows that they don't understand that, there's a real debate around these questions. The thing Kulldorff had said was that saying everyone needs the COVID vaccine is as unscientific as saying nobody does. It should be children don't need it.
It reminds me a little of the people who go to campus debates and then stand up when they don't like something and say, this is not a debate.
Exactly. Exactly. So, I mean, right now, the evidence of their censorship doesn't involve the government. We don't have any evidence that the government specifically asked Twitter to censor them, but
it's obviously right.
It's
we don't have, but the fact of the matter is they were doing this misinformation thing at the behest of the CDC's talking to them every day.
Exactly. We don't need direct proof that they were censored because of the government. Although I suspect, based on some things that Anthony Fauci and Francis Collins have said, that such evidence may turn up.
Well, and not only that, you don't have to have a written statement in this sort of thing. You can have circumstantial evidence so powerful that no other scenario bears out.
Right.
And for Kulldorff and Bhattacharya, I think it's really bearing out.
Yeah.
And none of that was produced in discovery, was it? It just came out in the Twitter files. How curious.
Exactly. And another really interesting thing that came out, I believe last week, was an internal Twitter document where an employee is summarizing a meeting with the White House and said the White House is very angry because we haven't been censoring people enough. They're putting a lot of heat on us. So again, that's more evidence that, they were ratcheting up censorship in response to the government.
And I think we should say we don't really handle the FBI part of this, but there's been an awful lot of talk about how what the FBI has done, and Missouri and Louisiana are very interested in those topics as well. It is.
And the FBI is a defendant here,
right?
So.
Exactly. And so, but I meant us at the NCLA. We tend to be, for our clients, it's COVID and vaccines and stuff like that. But I do think that we're going to hear more about this, and we'll see what the judge does with the motion to dismiss. And we'll be right back with Jenin. One of the things that I just saw was that the Canadian Licensing Board was going to have Jordan Peterson come before them for opposing the Trudeau administration. And I thought to myself, well, that will never happen here. But then it is kind of happening here. Whereas in California, the California government has passed a law that allows the licensing board for doctors to sanction and call people in for saying the wrong thing, not out anywhere, but to their patients. So they're intervening in the doctor-patient relationship to say that you cannot say certain things about COVID to various patients if it is not the approved view. So Jenin, tell me about the case. What's it called and what's going on? And am I right with what I just said?
Yeah, you got it. So the language of the law says that doctors can be sanctioned for spreading misinformation to patients about COVID in the context of treatment. So if you're at a dinner party, with some of your patients, that doesn't count. But if you're treating them, but the language says treatment or advice, and that's very important because the state can regulate conduct. And the distinction here, I think, is that treatment is conduct and advice is clearly pure speech. So the case here is we have 5 doctors in the state of California.
What's it called?
Hogue v. Newsom.
And where is it?
It's in the Eastern District, so that's Sacramento region. Dr. Hogue lives there. So all of our plaintiffs allege that their free speech rights are being violated by this law, that they can't speak freely to patients because they're afraid. First of all, they don't know exactly what the law is supposed to prevent. So the misinformation is defined as information that departs from the scientific consensus contrary to the standard of care. Now, we make the point that we don't know what the scientific consensus is on many of these matters. COVID is very new, and I don't think we want to take the position that there can never be a scientific consensus, because I think we can agree that
if they say that you got that you got COVID because your humors are out of balance, maybe you need a trip to the medical board.
But many of and I think when it's clear from the law's language. In fact, it cites low vaccination rates and doctors spreading misinformation about the vaccines. One of our doctors' specific fears is that some of them have said that they would want to tell some of their younger patients, especially those who've had COVID, that their risk of myocarditis is higher than any risk they face from COVID, myocarditis from the vaccine. So essentially, they would be advising some of the younger patients not to get the vaccine.
And for instance, if these doctors believe, I believe in the European Union, certainly, I forget which one it was, but one is particularly high for this myocarditis. And they have said, don't give.
I think it's Denmark.
Yeah.
Denmark or Norway?
But which vaccine? There's one particularly higher.
It's probably the Pfizer or Moderna.
Moderna. It's Moderna. Yeah. So the thing is, they've said, don't give it to young men 18 to 25 or younger.
Yeah.
And that has, and then they've given their reasons for it, and they've decided to say it. Now, do I know? I have no idea. But if your doctor has looked at this and he's the guy, should he not say that?
Yeah.
And then what happens if you're 18 years old and you take it, you get myocarditis, and you never said anything that you shouldn't do it?
Exactly. One of the points we're making too is, even if this law is never used against people like our doctors, they don't know that. So it creates what's known as a chilling effect in First Amendment law, where they're afraid to say it because they don't know if they might be caught up in this. And it's also important to note that they've been explicitly threatened on social media, 4 of the 5 plaintiffs, by doctors who brought the bill, saying things like, we can't wait till AB 2098 becomes law so that we can get your licenses taken away, for saying things like not all young men should get the vaccine, especially if they've had COVID.
Right.
And stuff like that.
And we've seen, I think, in this just this free speech area, is that when you cross the folks on the other side of, the people who thinks everyone should wear a mask and everyone should be vaccinated 27 times every month, that they're just very angry.
Yes.
And so who knows what they'll do. And I suppose to be fair, there are folks on the other side who are like, the vaccines have, Bill Gates put machines in the vaccines and they can't be dissuaded either.
Yeah.
So, but they're not going to control the medical boards.
No, exactly. And one thing we argue is that the California law disciplinary code already prevents doctors from doing things, committing malpractice, basically, or doing the sort of things that
the humors,
exactly. So it's my opinion, based on sort of both the language of the statute itself and the legislative history and these other doctors, that the purpose is really to silence dissenters when it comes to COVID, and people who have very legitimate views, backed up by studies themselves, just not the ones that the CDC chooses to cite.
I have a book because I represented in a past life somebody who disagreed with the quote scientific consensus on global warming, and she was a very big climate scientist and had a lot of background and things like this. But I wanted to show the court what had happened inside. Like, we have this view that it's so dispassionate and everybody leaves their feelings at the door and stuff. And I have this book, which is 10 scientific controversies. And one of them that always amuses me is because we think of these guys as almost like Spock, right?
Yeah.
No feelings, no anything.
Yeah.
And these 2 guys who had different views of how dinosaurs came about started stealing each other's dinosaur bones, and then they started like blowing up areas where there were dinosaurs with dynamite because they didn't want this guy to get the sample and have prove his view and not view. So that's an extreme example, but it is this weaponizing of disagreement in the scientific community cannot be good.
Yes, I agree with that. And, this is one of the other points we make. I mean, in the context of COVID, the so-called consensus is changing every day. So a year ago, or if you said the vaccines don't stop transmission, or you could still get COVID if you got the vaccines, that was considered misinformation. Now everybody agrees that that's actually true. The vaccines don't stop infection. They seem to reduce the severity of symptoms, although not necessarily the latest boosters.
And so, but what I find interesting about that is not only if it's true or not, there are some people, I think there's probably people on the California Medical Board who wouldn't want you saying that because it would create a tendency for people not to get vaccinated, even true information. And what we've seen, I think, in the social media area with what the government did is they didn't want true information coming out because it would cause vaccine hesitancy. Or they thought it would cause vaccine hesitancy.
And the doctor-patient relationship is supposed to be about individualized treatment, not blanket recommendations.
Right. And I do, and the absolute fear that someone's going to say something you disagree with, and then so you're going to punish them is coming into all areas with this, with this. And both these cases we've just discussed, the social media case and this one, are based on fear that you're going to say the wrong thing and we're going to punish you for it.
And that's why I think these cases are really important. And even though their legal theories are somewhat different, they're similar in the respect that you just identified. They're important because I think otherwise we're going to see a weaponization of these kinds of laws or policies in order to silence political dissent. And that's very dangerous. That's sort of why we have a First Amendment.
Well, not only that, it isn't anything like the Soviet Union, but what is a fact, something that happens in all totalitarian governments is they weaponize science to say that if you disagree with them, you're insane and you got to go into the insane asylum or all this. And there's a little whiff of that here in that once you've disagreed with, the world's foremost authority, you don't get to talk. And then we're going to take away your license to do to practice medicine and do your livelihood, and we're going to deny your patients access to you basically by doing that. I mean, it's a big deal.
Yeah, that's true. And so one argument the state is making, I think it's sort of important to cover this point, is that the state can regulate conduct of a doctor. And they've drawn an analogy to these gay conversion therapy cases where the courts have said that states can enact statutes saying licensed mental health providers can't do gay conversion therapy on minors, only minors. And they've said that's not speech because the speech is the treatment, basically. That's conduct, that's treatment. But here the statute says treatment or advice. So it's clear that they're drawing a difference. In the gay conversion cases, even said that the counselor can recommend that the child go get gay conversion therapy elsewhere at church, for instance, or after he's 18. So they've even, because those are recommendations and those are protected speech. So that's, and what we have here is much more analogous to that, in my opinion.
And I do think that, and the state can regulate medicine, but when they start, and it's one thing to say you got to have clean instruments, before you operate. If something, you can't rely on, although you do. One thing that always amazes me about these cases is that completely unproven treatments are allowed, right? You Medicare and Medicaid will pay for things like acupuncture, which a lot of people like, but does not have scientific double-blind tests about them, right? And that's okay. But here you have a bunch of scientific articles that have been double-blind studies, or at least studies of some kind that have scientific validity behind you, and you could be stopped. And you made the important point: the government won't say what they'll prevent. They won't say, okay, we will do this, but not that. And so nobody reading this statute and seeing this board knows how to direct their conduct, which is another thing. Can't have vague rules.
That's the other argument we're raising, and that's a 14th Amendment due process issue. It's called void for vagueness doctrine, because if you don't know what the law is, you don't know if you're breaking it, and that again creates a chilling effect. So the chilling effect applies to both claims.
Yeah, and we'll watch this case. I hope the hearing goes well. It'll be in like 10 days.
On January 23rd in Sacramento.
All right, and I think that we should We should do okay. I do think doctors of California should not be for this and should have fought against it, but we'll see what happens. We'll be right back.